Hi everyone, thanks for waiting. Good afternoon, I'm Jennifer. Thank you for spending some time with us today. In today's presentation, our speakers will be sharing on how to handle your trademark portfolio internationally and the benefits of obtaining protection in multiple markets. We also want to highlight some of the challenges when applying through the Madrid system and the ways to overcome it in order to manage your brand more efficiently. Before we begin, I would like to introduce today's speakers. We are pleased to have Hamta from our Malaysia office. Her scope of work includes managing the trademark portfolios of local and foreign clients from different sectors. She has also helped many clients with their international registration under the Madrid Protocol. Hamta is going to give us an overview of the Madrid Protocol application process and also particular procedural matters for Madrid filing through MIPO. Next, Zuhairy, who leads the trademark team in the Malaysia office, will also be presenting in this webinar. He specializes in filing, prosecution, and protection of clients' trademark both in Malaysia as well as overseas. He'll be sharing on how we can assist you in achieving your commercial aims in the most cost-effective way by doing a WIPO application. Our director, Kevin, will also be joining us today. He has many years of experience in the fields of IP management and transactional work. He is also a regular speaker in Singapore and other countries' IP events, and he'll be one of our panelists during the Q&A to answer any questions you may have. So if you have any queries along the way, you can ask via the Zoom Q&A chat box at the bottom of your screen, and we have time for questions at the end. So now let's welcome our first speaker, Hamta.
Thank you, Jennifer, and very good afternoon to all the attendees today. My name is Hamta, and I'd like to say a big thank you for joining our webinar titled Introduction to Madrid Protocol. So for all of you that attending our webinar today, by end of this presentation, you will be well informed on what is Madrid Protocol, the application process, including the basic requirements and the flow of the process. And most importantly, the pros and cons of the Madrid Protocol with real case studies so that you would understand more on the strategies of filing trademark application through Madrid Protocol. Further, I will brief on the things that you have to consider before choosing Madrid Protocol as your filing strategy. This will certainly help you to choose the right trademark filing route and avoid any problems in future. And lastly, as Malaysia has recently joined Madrid Protocol last year, we will look how this has affected the trademark filings in Malaysia as well. And day by day, we can notice number of companies operating globally is increasing, and the need for international trademark protection has also increased. Therefore, it is important that business owners to secure their brands or trademarks protection abroad. As we all might know, the trademark system is independent of each country in principle. This is where a Madrid system comes in handy, where business owners can apply for their trademark protection through Madrid system. So what is Madrid system actually? The system is based on both treaties, the Madrid Agreement and Madrid Protocol. Together we call it as Madrid system. In 1891, before Madrid Protocol was adopted, the Madrid Agreement was established as a system to facilitate international protection of marks, and the agreement is still in effect. So Madrid Protocol was adopted to add more flexibility to Madrid system so that more countries could join the system. So Madrid system is administered by International Bureau of World Intellectual Property Organization, or we can call it as WIPO, which is located in Geneva. And next, we'll look into the application process of the Madrid Protocol and what are the advantages and of the Madrid Protocol over national filings. Obtaining a trademark protection in several countries by filing separate application can be a very complicated and expensive process, as the trademark laws may significantly differ from one country to another. That is why we need the Madrid Protocol filing system, where filing a single application for an international registration, a trademark owner can obtain trademark protection in up to 122 countries. Therefore, filing a trademark application in several countries through Madrid Protocol is simple and cost-effective. And we will look into each of these points in depth shortly. As of now, the Madrid Protocol has 106 members and which covers 122 countries. From the diagram here, you can see all the blue regions are already joined Madrid Protocol, which covers like more than 80% of the world trade. Some of the countries that recently joined Madrid Protocol last year, 2019, are Canada, Malaysia, Samoa, and Brazil. Next, we will see what are the requirements and the flow of the application process of Madrid Protocol. First of all, in order to apply for an international registration to Madrid Protocol, trademark applicants still need to meet a certain requirements that enable them to apply for this kind of protection. The applicant must have an active application or registration for the trademark in a Madrid Protocol member country. And this country must also qualify as the owner's country of origin. Means the owner could be a citizen of the home country or domicile or has a real and effective commercial establishment. The initial filing is referred to as basic application or basic registration. For example, if you have a domicile in Singapore and you would like to register your basic application at Singapore Registry, and then you could extend the application to other desired countries through IP registry at Singapore. So under the protocol, the international registration should be based on a basic application registration. This means Madrid applicant must be the same as the proprietor of the basic application registration, and the goods and services of the Madrid application must be within the scope of the basic application. It also means that we cannot add more clauses to the international registration from what has been applied in the basic application. But the specification goods can be narrowed, or you can remove some of the clauses in the international registration. First of all, in stage 1 of the application process in Madrid Protocol, the basic applications have to be filed at the office of origin, followed by the international application to be applied at the same office of origin. After you have filed the international application at the office of origin, then the office of origin will certify and forward it to WIPO. Once WIPO receives the international application, it performs a review to ensure the owner has complied with all the formalities, including payment of WIPO's official fees. If WIPO detects any irregularities, it will issue an irregularity notice to inform the owner, who usually is given 3 months to respond. And if WIPO does not found any irregularities, it will promptly issue a registration date and number. And although the registration is not yet in effect, in any country, the owner is said to own international registration. So after that, the international registration will be published in WIPO's official gazette. Thereafter, WIPO then forwards a request for extension of protection to the trademark office in each country designated by the owner in the international application. Once each designated trademark office receives the application from the WIPO, it is given the chance to examine the request in accordance with that country's usual procedures and decide whether to permit the international registration to take effect there. The whole process of examination, objections, and opposition is done by each trademark office individually. Furthermore, the designated trademark office has to issue a decision within 12 to 18 months. If not, the owner of the trademark registration will be automatically granted for protection of the mark. So some of the obvious advantages you can gain from trademark registration under Madrid Protocol that applicant of the mark has only need to file one application in one language and pay one fee in single currency instead of filing separate applications in the trademark offices of the various countries in different languages and paying a separate fees in the local currency to each country. Since you can handle all the process of registration in one of the official languages, which are English, French, or Spanish, there's no need to use the official language of the designated country. So the applicant here can save cost on translations as well. And there is also centralized management for renewables and change of address or name or any recorders. So this will be very convenient for you to manage your trademark portfolio better. And from the diagram here, you can see that there is a significant difference in the costs involved between Madrid Protocol application and national filings. In the Madrid Protocol, obviously, the applicant does not need to hire services of a local agent to file the application mark in each of the designated country. That will significantly reduce the legal fees. Local agent is only required when a refusal is issued in a country, so that prosecution costs only incurred on a need-to basis. Furthermore, there is a fixed examination period of up to 18 months for IP officers to raise an objection to the trademark application. In the absence of any such objection, the application will gain automatic protection. When an applicant makes an application under the protocol, they can know for sure that in not more than 18 months, the examination process will be concluded, and that provided there was no opposition, the trademark will be registered in all of the designated countries. Also, through Madrid Protocol, you may claim priority for the international registration, provided that applicant have to apply for the international registration within 6 months of filing its basic application in the office of origin. Now, we will look into the restriction or limitations that we might face through Madrid Protocol. Now, the limitation that we have to take note while considering Madrid Protocol is that international registration has to be similar to the basic application, which means the mark applied has to be same as in the country of origin and all the other designated countries. This means the applicant cannot apply for a variant of the marks under Madrid Protocol. So the business owners might not possibly separate marks for different markets that will fit to the local consumers. In global marketing strategy, brands do use different names in various territories, or sometimes existing businesses might have trademarks that affect your brand. If the applicant need to rebrand their products, it is not ideal to use a Madrid Protocol system for their trademark filings. For example, here, the very well-known food chain called Burger King has to call as Hungry Jack in Australia. This is because before Burger King expanded to Australia, the name Burger King was already trademarked by another restaurant. In this case, since the marks are different in different countries, Madrid Protocol is not the right route to gain trademark protection. And another reason for business owner to use variants of mark in other countries is to adapt to the local language so that their products can relate to their consumers more. Therefore, with Madrid Protocol, the business owners unable to file the mark in Chinese, Japanese, or Korean character, which is how most of the marks are best protected throughout the Southeast Asian countries. For example, the UK clinic brand, Mr. Muscle, is known as Mr. Maestro Limpio in Mexico and Mr. Proper in Europe. So here, marks are adapted to local language of a country to promote their brands. And another example will be, you might know Lay's chips in US, but in UK, Lay's is called as Walkers. And in Australia, the same chips are called as Smiths. This is because PepsiCo Inc., the owner of all these brands, acquire local businesses and keeps the original names when they expand into new markets. They have also combined local language characters to their brands for Asian markets, especially like China, Thailand, Japan, and so on. As you think about your global marketing plan, research your brand and how it might connect with consumers across markets. It's also worth checking that your brand name isn't deemed rude or inappropriate in certain languages or cultures. In that case, it is better to choose national filings compared to Madrid Protocol, since Madrid doesn't allow series of marks or variants of marks to be filed through the system. Another limitation of the Madrid Protocol is each member state of a protocol has its own definitions and interpretations of goods and services. And this means that what is acceptable for one country may not be acceptable for another. While the NIS classification is applicable to the Madrid system, it does not override the national classification system of each country. Each country has their own interpretation of what goods and services should be classified in what way. And although this aligns nicely in many cases with NIS classification, in many other instances it does not. For example, the term clothing accepted in Malaysia, Singapore, or Philippines, but in Thailand, it has to be specified as skirt, hat, or scarf. The specification of list of goods and services in the international registration can be a difficult task. Not only you need to consider that the basic application meets the requirements of the NIS classification, but we also need to ensure that it meets the requirements of each classification system of each designated country. If there is any amendments required by any of the designated countries, the applicant had to add a classification to the basic application or registration or make an entirely new basic application to ensure classification compliance with WIPO and all the other designated countries. Therefore, it is more advantageous for the basic registration of a trademark to be secured in a country with less stringent requirements to avoid any objection. Another example is the classification system in China. The China Trademark Office divides each NIS class into a unique system of subclasses for a purpose of trademark registration. A trademark for one item in a given subclass covers all the items in that subclass only. To see how it works, let's look at the NIS class 41, for which the official heading is education, providing of training, entertainment, sporting, and cultural activities. The Chinese registry divides class 41 into 7 different subclasses. When we file a national application in China, we have to determine the subclasses that an application covers. But when you file a Madrid application, the list of items filed in basic application goes straight to the examiner, who will decide from the list which subclasses the item should go in without consulting the applicant. So at that moment, the examiner might miss out the subclasses that the applicant likes to protect. In this case, let's say the examiner has decided that specification of goods applied in basic application does not cover subclasses highlighted in red in the slide. So this will give way to other people to file similar mark in the subclasses that have been missed out. Also, we have to note that items in different subclasses are generally not considered similar to one another. Here you can see that company A, B, and C own the same mark in different subclasses. This also means that you can't stop people from using your brand in subclasses you don't have coverage in. And other people can even register their own identical trademarks in these subclasses and exclude you from using your brand on these goods. The most famous case of trademark being misfiled because of the subclass system will be that of Apple's iPhone mark. In 2002, Apple filed an application under subclass 901, which covers computer hardware and software, expecting it to cover cell phones. However, cell phones were in fact covered under different subclass. But a Chinese company, Hanwang Technology, applied for the same mark, iPhone, under the correct subclass, which is 907. As a result, Apple lost the appeal and ended up paying Hanwang Technology higher price to get the trademark right. So this shows why choosing a national filing route in China is more advantageous than the Madrid Protocol route. However, businesses should be aware that regardless of the part they choose to facilitate their Chinese trademark, investing in a clearance search of trademark before filing application will avoid potential objection, refusals from the registry. So therefore, for your key marks, it is advisable to file them in China directly with specifically drafted trademark specification covering all the subclasses or as many relevant subclasses as possible within each class. This will provide the broader scope of protection for your mark and leave no loopholes for trademark infringement. So another disadvantage of Madrid Protocol is called as central attack, because there is a dependency period of 5 years on the basic application for international filings. This means when a basic application is cancelled or withdrawn or refused within the first 5 years of the application date of the international filing, it will result in the rejection of all the application in other territories that are based on that. But after the period of 5 years, the international registration is independent to that of basic registration of that mark. No worries. Even if the international registration is cancelled through the central attack, the international registration can be transformed to national filings within 3 months after the international registration is cancelled by central attack. This transformed application will be given the date of the original international registration. It is worth to note that the transformation of international registration to national application is not available if the owner himself cancels the basic application. So as a preventive measure to avoid the central attack, the applicant is encouraged to do full availability search to make sure that there is less possibility for the base application to receive any refusals to register a mark application that lacks distinctiveness or it is too similar to prior marks. So this scenario can be observed in the case of well-known toys brand Lego and Lepin, where Lepin logo is accused of imitating the mark Lego. Lepin trademark owner Shantou Meizi model has used the Chinese application as a basic for designating 47 other countries around the world. And since Lego has won the opposition against the Lepin logo, this means that all the applications for the Lepin logo filed in 47 countries will be cancelled as well. And this is how central attack to the basic application or registration will affect the Madrid international filings. So, so yeah, another limitation is restriction of transferability. This means the Madrid Protocol international registration cannot be assigned to businesses that is not qualified to file an international registration under the Madrid Protocol. So brand owners must also bear in mind that this restriction means international registration cannot validly be transferred to any potential purchaser from a non-Madrid Protocol country. In order to transfer the ownership to non-member countries, the trademarks application will have to be withdrawn from the Madrid system first. And as a result, the Madrid Protocol cannot add additional value for registration that trademark owners hope to transfer or assign to non-member countries. we will now look into the Malaysia's accession to the Madrid Protocol. So how this has affected Malaysia in their trademark filings. So the Madrid Protocol has came into force in Malaysia on 27th December 2019. And in accordance to that, the Trademark Act has been amended to align with the requirements of the protocol. Some of the important changes that we have to take note are now Malaysian Trademark Registry allows registration of non-traditional marks, that is sound, color, shape, scent, or hologram, or any combination of those. And secondly, trademark owners can file a multi-class application in Malaysia. This is very convenient for brand owners to monitor a single application uh, instead of separate application for each class. And next, under the new trademark law also, the applicant can file for division and merger of application or registration. And this means a trademark application covering multiple classes may be divided into two or more separate application or separate application merged into one single application. And this can be very helpful, for example, when the trademark office issues a refusal in respect of only some of the classes of goods or services of multi-class application, where the applicant can file for division of the application to enable the accepted classes to proceed to registration without being delayed by the refusal issued in respect of other classes. This provides flexibility to the applicant of the trademark to manage the portfolio better. Lastly, uh, there is no longer any requirement to file statutory declaration or ownership or power of attorney to support the filing of a new trademark application in Malaysia. So the filing of the new trademark application has been made even more convenient under the new act. So before you file a Madrid Protocol application, the pros and cons should be considered before deciding to rely on the Madrid Protocol for trademark protection in other countries. Make sure the base application will less likely get any objection due to distinctive or descriptive marks or due to prior similar marks. Therefore, current expressions are preferable as more likely to be inherently registrable, and descriptive or generic terms may result in objection and eliminate the cost-saving advantage of Madrid Protocol, because the applicant might need to spend on local attorneys to handle such objections. And also, if the variants of marks will be filed in each designated countries to adapt to the local consumers, then national filings will be more ideal compared to Madrid Protocol. Trademark owners might protect their marks with the combination of national filings or regional filings such as European Union or African regional trademarks, and also international filings to Madrid Protocol. For instance, brand owners often continue to file separate national application in Japan or China rather than including it as an international filing. In this way, they can secure registration in the world's largest economy market rather than international registration extended to Japan or China, which may subject to central attack for the first 5 years from the basic country application filing date. Depending on their commercial strategies, business owners will have to pick and choose among registering their marks as international registrations, regional trademarks, or national marks to gain global protection. Besides that, applicants should make sure that there is no intention to transfer the ownership of a trademark to non-member of Madrid Protocol, as this is not allowed in the Madrid Protocol system. To ensure that a mark will not infringe upon the rights of others, applicants are advised before filing the basic mark to search for possible conflicting prior marks. And also, consider waiting for a home application or the basic application to clear opposition period before filing international application to avoid risk of central attack. Consider the option of filing an international application on the basis of basic registration rather than on a basic application. So as a summary of this presentation and to compare between international filing and national filing, let's say a business owner planning to file a trademark application um, for his mark worldwide. How he should choose the route for his trademark filing. Is he going to market his product with the same mark around the world? Then he might file his trademark under Madrid system, where he can simply file one application for all the countries he prefers without spending so much of money on separate applications. He can even file for renewals for all the applications worldwide with one renewal form. So it is very easy to maintain such a bundle of application all for many countries. Or the business owner plans to use variants of marks to fit the local consumers of certain countries. Then he might choose national filings instead to file such marks. And also for the larger economical market, it is advisable to file a trademark under national filing to avoid risk of central attack. Lastly, before filing Madrid system, make sure the basic application covers broad range of specification of goods and services, and it also advisable to file basic application in the country where there is more flexibility on classification of goods and services, so that the international registration can cover wider range of goods in all the designated countries. So we recommend including the Madrid Protocol option as a part of considerations for international filings strategy, but it is important to appreciate it is not always the best filing option in every circumstances. Madrid applications are supposed to be less expensive and quick, but fixing the Madrid problems after the fact is not. I hope this presentation has been informative and has given you some ideas on strategies for your trademark filing. Thank you for listening uh, this webinar so far. Thank you.
Thanks so much for sharing this useful information. Zuhairy, you have some experience with filing WIPO applications. Other than it simplifies the trademark registration and management procedures, how do businesses make the most out of this system?
All right. Thanks, Jen. Um, Thanks, Hamta, for the presentation. And good afternoon, ladies and gentlemen. Thanks again for joining us. I won't add much to what Hamza has presented. She's pretty much covered all the basics of the Madrid system. I'll just take about 5 minutes of your time to explain how Madrid can be an effective tool for the development and promotion of your business, especially those entrepreneurs amongst us who have active business interests in multiple countries. And the Madrid market, ladies and gentlemen, is huge. It gives you access to 107 members, comprising 122 participating countries and territories. And as you already know, and as Hamta explained earlier, Madrid is a convenient one-stop system for business owners to register their brands overseas without the need to file separately in each country of interest. And this one-stop system allows trademark owners to file in all the targeted countries at one go. So instead of paying separate fees in each country, you pay only one set of fees, and you've already made the first significant step towards protection of your mark in multiple countries. And furthermore, you don't have to pay any translation fees either, which can cost you quite a lot. Because all Madrid filings are in either English, Spanish, or French, which are the three recognized languages of the Madrid system. And regardless what languages are actually spoken in the designated countries, the filings will always be in either one of these three languages only, as they are the only ones which are official for WIPO purposes. And usually we will go with English, being the most widely used and understood. As for the payment itself, the great thing about Madrid filings is that WIPO's base fee, no matter how many countries you file in, it remains the same. And but yes, there's naturally additional fees charged by the targeted countries, which will vary according to each trademark office. Nevertheless, it would still be much cheaper than filing individually in each country, because that would mean separate fees for separate jurisdictions. But convenient as the Madrid system is, yeah, there are still some things that you need to look out for, especially during the examination stage. Like, for example, if an application in one or more of the countries you file in is faced with an objection, this has to be dealt with separately with the local trademark office. And actually, this is where we at Cheong can play a role in assisting you with overcoming the objection. Also, let's say if you come under central attack, meaning your home application is objected, and this objection is eventually not overcome, then it is possible that the other applications will be converted into national filings or applications, which is also a situation in which we can come in to assist, owing to a well-established network of associates around the world. So whether you want to go the Madrid route or a regional route, or if you prefer a hybrid approach by filing a Madrid application in some countries while applying for national level application in other countries, whatever the case may be, whatever suits you, you can count on us to come up with the best filing strategy for your particular needs. So in a nutshell, there's so much more that you can do for your trademark, and you can take your branding to great lengths if you do your international trademark filings via WIPO. It's an excellent platform for the protection of your brands in the worldwide export market, and it is a cost-effective strategy for the internationalization of your marks. So yeah, we do hope that we've helped you see the numerous advantages you can get from a Madrid filing. In particular, its cost effectiveness, and especially considering that you will unlock access to the worldwide market. So if you have any additional questions or concerns about the Madrid system, we have a dedicated team of professionals here. We have plenty of experience in this field, and we'll always be ready to assist you. So yeah, let us help your trademarks travel the world and tell your business story to your global population. Thank you.
Thanks again, Hamta and Zuhairy, for the great presentation. We have a handful of questions which we'll go through shortly. If there's anything you would like to ask, you may ask us now, and we'll do our best to answer all of your questions. So the first question is, what is the time period for an application to act as basic application for international filings? This question is more related to your presentation, Hamta. Would you like to take this question?
Sure. So to answer to this question, right, actually there is no time period or expiry date for a application to act as a basic application for any international filings. So as long that any application can serve as a basic application, as long that base application is actively registered in any of the Madrid countries. Yeah. Thank you.
Thanks, Hamta. Our next question is, I've heard that clearance searches are important before filing an international mark. How do I know where I should conduct such searches, and are these really necessary? Zu, perhaps you would like to answer this question?
Yeah, well, as far as being necessary is concerned, no, they're not actually necessary, but they are important because clearance searches, although they are not mandatory, we can think of them as risk management or due diligence exercises for your trademarks. So just to make sure that your trademarks do not conflict, they say they look similar or identical to a mark already existing in the registry of the country you're interested in. Yeah? And in fact, we usually do searches as a matter of course to minimize or at least gauge the risk of a citation refusal by the national trademark officers later on. And well, as for where to do the search, well, some national offices do have search functions on their websites, but it's sometimes the case, right, that the information may not be up to date or is incomplete, because some national websites that I know of, they only limit the search results to maybe a few thousand trademarks. So you might still need to engage someone on the ground to conduct the search for you according to the most up-to-date information in the respective trademark offices. Yeah. Hope that answers your question.
Yeah, thanks for this detailed answer.
Mm.
Kevin, would you like to add on to that?
Well, I don't have too much to add. Hopefully you can hear me. Not too much to add. The concept of dealing with conflict or doing conflict searches is a what your typical IP practitioner would recommend. It's of course is an exercise which would incur costs, and so I think there can be certain ways of dealing with it according to the scale of searching that would meet the budget of the business. I think we are talking, especially if we're talking about a Madrid Protocol base application to be filed, and then followed by the designated country filings under Madrid, then the vital country to search at the very least would be the base country, because the vulnerability of the entire Madrid application may actually fall on what happens to the Singapore, or the base application. Let's say it's a Singapore applicant and they are using their Singapore application as a basis. This will apply to all other countries where the applicant is from another country and they are basing on their country's base application. So at the very least, I think we recommend to deal with do a search in that country, and if the budget permits, to extend that search to the other countries, so the applicant has a better feel for an assessment at an early stage as to the possible issues as to availability of their trademark. It might at the end of the day, with a comprehensive search, the applicant may actually come to the conclusion that probably this is not a very good idea. This particular mark they have in mind, they might actually think of something quite major, even to the extent of saying, let's try a different brand. Or other strategies, which may include coming up with different brands for the same product, just to get around known issues in certain countries. And if they do that, then obviously, because the Madrid application takes only one mark and you designate that same mark in the various countries, you'll probably be looking at some national applications directly with the IP officers for that sort of strategy. So I'm going to in various kinds of scenarios that may pop up, and there are a lot more. And your IP practitioners are the ones who will be able to advise along the way, advise you along the way for any particular case you're doing in terms of a trademark application internationally.
Okay, thanks, Kevin. We have another question which is related to your presentation, Hamta. What will be the filing date of Madrid Protocol applications for the subsequent designated countries?
Okay, the filing date for the Madrid application, right, is the date the international application filed with the Office of Origin. If the application reaches like WIPO within 2 months, but if not, otherwise the filing date of the international application will be the date on which the WIPO receives the international application. So yeah, thank you.
Okay, thanks, Hamta. Our next question is, can I know which countries have stringent requirements for specifications? Kevin, perhaps you'd like to take this question?
I was thinking Jennifer had me in mind for this question because we discuss these things from time to time while doing our work. Well, there are certain countries that are rather particular or specific in their own concept of what's acceptable and what's not acceptable in terms of descriptions of goods and services. I don't have a comprehensive, exhaustive list, but I can just name a few. We're talking about the ASEAN region. One of the most robust in examining descriptions of for goods and services is Thailand. The common issue that may arise for an application filed in Thailand would be the descriptions of goods and services. The issues that may arise are pretty much the same whether you file directly, as in a national application, or whether you file an international application and designate Thailand. So pretty much no difference. You get the same treatment, and that's actually by right how the individual country local IP officers are supposed to process applications. There should be no difference in the examination standards. Yeah, so Thailand is one of them. I'll be looking further abroad. We have, let's say, I would pick up the United States. The USPTO, the IP office of the United States, the officers do quite a stringent examination on the descriptions of goods and services as well. And there are certain kinds of language that they might feel is more appropriate for acceptance for US applications. So I think I just said these two at this point in time I would bring up. As for other countries, they might be quite, generally the countries around the world would be quite accepting of your niche classification accepted goods and services. And so you may not have so many too many problems in generally speaking, but again, that's where our IP practitioners like ourselves can come into the picture when issues arise, and it can happen even if you think you have gotten your descriptions quite all right. The IP officers may still raise some issues along the way, and that's where we might come in. IP practitioners may come in.
Thanks, Kevin. We now go to the next question. This question is for you, Zu. How would I know which mark I should file internationally and which mark is better to file in individual countries, which I assume it means like locally? Zu, would you like to take this question? Zu? Okay, seems like we're experiencing some technical difficulty. Okay, we'll just give him like 5 minutes to rejoin. And how about in the meantime, Kevin, would you like to take this question?
Actually, I was just going to add on this so-called descriptions of goods and services item. I think it might be worth noting that there's some countries, I think there are not many at all, where the concept of specifications of goods and services has to be, so-called examined even more carefully. For example, in Indonesia, right now, if you were to file nationally, you are quite so-called stuck with having to file your applications based on a very fixed and specific set of descriptions that the Indonesian IP office will accept for filing. And if your descriptions don't fall within these fixed sets of descriptions, you can't even file your application. So with that in mind, possibly to try and at least at the initial stage kind of circumvent or avoid this rigidity, you could actually designate Indonesia under Madrid Protocol, thereby kind of like going past the very stringent e-filing system process that the Indonesian IP office is currently administering or using for national filed applications. So you can see from what I'm saying that while there might be disadvantages of the Madrid Protocol system, there are certain instances where actually the Madrid Protocol system may help your application go through with less complications. Yeah. What was the other question that Zuhairy was supposed to answer, but he's currently not unable to?
Seems like he's still having a bit of difficulty. The question is, how would I know which mark I should file internationally and which mark is better to file in individual countries?
Okay. I think this is quite a broad question in terms of the various ways it might be answered. A lot of the specifics of to address this question would probably go down to knowing what the actual specific case facts are, what sort of geographical scope is involved, and various things like that, and also the business area. But I think there are maybe one or two things I can bring up as to, I think the question really goes down to, which mark should be one which, or I'll go the Madrid Protocol International Application way, and which type of mark will be, I should just do national direct filings. I think one factor might be the scale of your project. Now, generally for me, when I review, the incoming kind of inquiries or on interest on filing internationally, I'll ask this question: what's the scale? Now, if you're looking at only maybe one or two other countries, let's say beyond your home country, I would generally not really recommend strongly going the Madrid way, purely because the administrative convenience factor as well as the so-called cost saving factor are not very strong factors where your scale is not there. And if you're talking about just let's say if you're a Singapore company and saying, I'm just going to designate Malaysia and Thailand, for example, I would probably tell the business owner, probably you're pretty fine just filing directly, doing a national application in Malaysia and Thailand, and you get the kind of upfront treatment of viewing the applications and all that. So and in terms of the costing, I don't think there'll be a major difference where the scale is so small. So the benefits of filing Madrid are not so strong when the scale is small. I think that's one more possible thing to think about is also where you, let's say, if let's say you have a mark where your base application, you have a base application, so it's not a registration, and you don't, the business owner does not want to do any kind of clearance search. So there's some uncertainty as to whether the application, that base application, is going to be good and going to get through in the first place, or a clearance search is done, and for that base application, or for the country, the base country, the mark does not look like it's entirely clear, and the applicant or the business owner foresees possible obstacles for even their base country application when they do file it, then probably it might not be such a good idea to go the Madrid way, because if something really goes wrong with that base application, then there's the additional layer of transformation down the road. Because there will be this central attack thing that happens, and there'll be additional cost of converting their destination countries into national applications. So maybe in that sort of situation, going national might be a better idea. But there'll be the upfront cost of doing national in that kind of scenario.
Okay, thanks Kevin for taking this question. We're running a little bit behind schedule, so we take one last question. Kevin, perhaps you'd like to take this question. If there's only one or two designated countries, is it worth or cost saving to use the Madrid Protocol route?
Yeah, I believe I already answered that question just now. If it's just one or two countries, then, well, the Madrid Protocol can serve its purposes in terms of administrative convenience. But like I mentioned earlier, I think the benefits of that administrative convenience are not as strong or not as great as compared to where you have many countries that you're designating. Then all your subsequent actions like renewals and all that, renewing the international registration, covering all those countries, it looks like it's a much more convenient kind of way of doing things. But if you just have one or two countries, then you can actually do that quite relatively simply without even having a international registration kind of mode of protection for that kind of situation. So yeah, the fewer the countries there are, I think the less beneficial would the Madrid Protocol system be, in my opinion. Yeah, but you can still, of course, use the Madrid Protocol. There's nothing to stop a business owner from using Madrid Protocol, even for a small scale exercise of designating countries.
Okay, thanks Kevin. Thanks everyone. I hope everyone found this session fruitful and engaging. If you need further information or clarification, you can always email us at mail@cheong.asia and we'll get back to you as soon as possible. We'll also appreciate it if you can take a few minutes to fill in the survey questions, which will pop up on your screen after these webinars. Thanks again, everyone, and have a nice day. Bye.
Thank you.